I was sitting at my kitchen table in Scottsdale, Arizona, working on a brief for an upcoming Supreme Court case when I heard a key turning in my front door lock. My coffee mug froze halfway to my lips as the door actually swung open, and two men in cheap security uniforms walked straight into my living room like they owned the place. "Excuse me." I stood up so fast my chair scraped across the tile. "Who the hell are you and why are you in my house?" The first guard, a heavy-set guy with a patchy beard, barely glanced at me. "Monthly HOA inspection. We're checking for code violations." "Monthly what?" I moved toward them, my legal instincts kicking into overdrive. "You just used a key to enter my private residence without my permission." The second guard, taller and thinner, pulled out a clipboard. "It's in the HOA bylaws, sir. Random inspections are permitted to ensure community standards. We have master keys to all properties." I felt my blood pressure spike. 20 years as a constitutional lawyer, specializing in property rights and Fourth Amendment cases, and I'd never heard anything quite this audacious. "I want you both out of my house right now. Whatever you think your authority is, it doesn't extend to unlawful entry." The heavy-set guard finally looked at me directly. "Sir, if you refuse to cooperate, we'll have to report this to the HOA board. You could face fines starting at $500 per day." I pulled out my phone. "Get out now, or I'm calling the police for trespassing." The thin guard stepped forward. "We have authorization from Patricia Wellington, the HOA president. If you want to dispute this, you'll need to attend the next board meeting." Patricia Wellington. I'd met her exactly once during the closing on this house 6 months ago. A woman in her late 40s with an aggressive blonde bob and the kind of smile that never reached her eyes. She'd cornered me for 20 minutes about the importance of maintaining neighborhood excellence while I tried to get my keys and leave. "I don't care if you have authorization from the governor. This is my home and you're violating the Fourth Amendment right now. Out." They exchanged glances and the heavy-set one shrugged. "We'll be back next month. Make sure you're more cooperative, Mr. Irwin." After they left, I stood in my violated living room, shaking with anger. The fact that they had a key to my house, that they felt entitled to just walk in whenever they wanted, was beyond outrageous. I'd handled cases involving overzealous HOAs before, but this was next-level tyranny. I spent the next 3 hours digging through every document from my home purchase. The HOA covenant, conditions, and restrictions ran to 47 pages of dense legal text. I'd skimmed it during closing, like most people do, focusing on the big items like architectural approval requirements and monthly dues. Now, I read every single word. There it was, buried in Section 32, subsection 14. The association reserves the right to conduct periodic inspections of all properties to ensure compliance with community standards. Homeowners agree to provide access as requested by authorized association representatives. Vague, overreaching, and almost certainly unenforceable, but there it was in black and white. Someone had clearly convinced the previous board to add this language, and apparently Patricia Wellington was taking full advantage. The provision said nothing about master keys or unannounced entry, though. That was an escalation they'd added on their own. I called my friend Marcus, who practiced real estate law in Phoenix. "Tell me about Sunset Ridge HOA, I said when he picked up. "Oh man, you're in Sunset Ridge. I'm sorry." "That bad?" Patricia Wellington took over as president about 18 months ago. "We've gotten complaints, but nothing anyone's been willing to pursue legally. She's turned that place into her personal fiefdom." "Why, what happened?" I told him about the guards with keys. He whistled low. "That's criminal trespassing, Sam. I don't care what the bylaws say. You can't just walk into someone's house. That's what I thought. I'm going to their next board meeting. Want backup? This should be interesting. No, but I might need your help shutting down their entire operation if this goes the way I think it will. The board meeting was scheduled for Thursday evening at the community center, a bland stucco building near the front entrance of Sunset Ridge. I arrived 15 minutes early and found about 20 other homeowners already there, sitting in folding chairs facing a raised table where the board would sit. The energy in the room was tense, subdued. People spoke in whispers. I took a seat in the back row and observed. Most of the attendees were couples in their 30s and 40s, a few retirees, one young single woman who looked fresh out of college. They all had the same tight expression around their eyes, like people who'd been ground down by bureaucratic warfare. At exactly 7 p.m., Patricia Wellington entered through a side door, followed by 4 other board members. She wore a white pantsuit and carried a leather portfolio. Her blonde hair was sprayed into immobility, and her makeup was applied with the precision of someone preparing for battle. "Good evening," she said, settling into the center chair. Her voice had a sugary coating over steel. "Let's begin with roll call." The secretary, a nervous man named Donald, called out names. Then Patricia launched into reports from various committees. Architectural Review had denied 3 homeowners' requests to change their paint colors. Landscaping had issued 6 citations for unapproved plants. Finance reported the HOA had a healthy reserve fund of $200,000. During the architectural report, I learned that one homeowner had been fined $1,500 for installing a front door that was the wrong shade of brown. Another was facing legal action for refusing to remove a solar panel that was supposedly visible from the street, though the homeowner argued it was on the back of the roof and only visible from a specific angle. "We maintain standards for everyone's benefit," Patricia said. "Property values depend on uniformity and excellence." Finally, 45 minutes in, she called for new business and homeowner comments. 3 people ahead of me stood to speak. The first, an elderly man named Harold, explained that he'd been cited for having his garbage cans visible from the street on a non-collection day. He'd actually been taking them to the curb for the next morning's pickup at 7 p.m., as he'd done for 3 years. The citation came at 7:30 p.m. "The rule is clear," Patricia said. "No trash containers visible from the street except on collection days. But collection is the next morning at 6 a.m. When am I supposed to put them out?" "That's your problem to solve, Harold. Perhaps set your alarm earlier." Next. A young couple stood together, the wife speaking. "We got a notice that our fence is half an inch too tall. We had it installed 6 years ago before we bought the house. The previous owners got it approved." Patricia shuffled through papers. "The approval was for a 5-foot fence. Yours measures 5 feet and 0.5 inches. That's a violation. But we didn't build it in half an inch." "Really?" "Standards exist for a reason, Jennifer. You'll need to have it modified or face daily fines starting at $100. Next. The third person was the young woman I'd noticed earlier. She looked terrified. "I got a notice that my car is too old to park in my driveway. It's a 2015 Honda Civic. It runs perfectly fine." "It's 7 years old and has visible wear," Patricia said. Section 19, subsection 8. No vehicles older than 10 years or showing significant cosmetic damage may be parked in driveways or visible from streets. Your car has a dent in the rear bumper. "I can't afford a new car right now. I'm a teacher. Where am I supposed to park?" "You could repair the dent or park in your garage." "I use my garage for storage." "Then you'll need to reorganize. Not my problem." Patricia's smile never wavered. Next, I stood. The room's energy shifted as everyone turned to look at the new voice. My name is Samuel Irwin. I live at 2847 Desert Vista Drive. Last Tuesday, 2 security guards entered my home without my permission using a key I did not provide. Patricia's smile tightened. Yes, Mr. Irwin, I heard about your lack of cooperation with our inspection program. There was no lack of cooperation. There was an illegal entry into my private residence. I'm here to inform you that this practice ends immediately. The bylaws clearly state, the bylaws are subordinate to constitutional law, Miss Wellington. The Fourth Amendment protects against unreasonable searches and seizures. You cannot enter private homes without consent or a warrant. A murmur ran through the crowd. Several people sat up straighter. Patricia's expression hardened. This is a voluntary community with agreed-upon rules. You signed the covenant when you purchased your property. I signed an agreement about architectural standards and maintenance requirements. I did not waive my constitutional rights. No contract can require citizens to surrender fundamental protections. Mr. Irwin, I don't know what you think you know about the law. I'm a constitutional attorney. I've argued cases before the Supreme Court. I know exactly what the law says. I kept my voice level factual. If those guards enter my home again without my explicit permission, I'll have them arrested for criminal trespassing. If the HOA retaliates against me in any way, I'll file suit in federal court. Patricia stood, her chair scraping back. Are you threatening this board? I'm informing you of the legal consequences of your actions. There's a difference. She gathered her papers with sharp, angry movements. This meeting is adjourned. Donald, make a note that Mr. Irwin's comments are under review for violation of our civility policy. There's no civility policy in the bylaws, I said. Board members will convene in private session. Everyone else, please leave. The crowd filed out slowly, several people glancing at me with expressions ranging from awe to concern. In the parking lot, 3 homeowners approached me. Is what you said true? Harold, the elderly man, asked. About them not being able to enter our homes. Absolutely true. Has this happened to you? Twice. They came in while my wife was in the shower. She was terrified. That's criminal, I said. That's not just a civil dispute, that's trespassing and potentially worse depending on the circumstances. The young couple, who I now knew were Jennifer and Craig, joined us. They came into ours last month, Craig said. They cited us for having the wrong brand of light bulbs in our kitchen fixtures. They were literally inside our house, looking in our cabinets. How many people has this happened to? I asked. Most of the neighborhood, Jennifer said. People are scared to fight back. Patricia finds anyone who disagrees with her. The Johnsons down the street are facing $20,000 in penalties for refusing to cut down a tree that's supposedly too tall. Do you still have your citation notices? Any documentation? Everything, Harold said. I keep it all in a file. I'm retired military, I document things. Would you all be willing to be part of a class action lawsuit? They exchanged glances. Craig spoke first. What would that involve? We'd sue the HOA for civil rights violations, breach of contract, intentional infliction of emotional distress, and potentially several other causes of action. If we win, the court could invalidate the inspection program, award damages, and force the HOA to reimburse your legal fees. How much would it cost us? Jennifer asked. If we do it as a class action, we could share costs. But honestly, given how egregious this is, I might be able to get colleagues to work pro bono or on contingency. The constitutional violations alone make this newsworthy. Count us in, Harold said. My wife hasn't felt safe in our own home for months. I got their contact information and told them I'd be in touch. As I drove home, My mind was already organizing the case. This wasn't just about my house anymore. Patricia Wellington had systematically terrorized an entire community, hiding behind bylaws that had no legal force against fundamental rights. The next morning, I started making calls. My first was to Detective Angela Ramirez at the Scottsdale Police Department. I'd worked with her on a criminal case 2 years ago and knew she had little patience for people who abused authority. "Sam Irwin," she said when she answered. "Haven't heard from you in a while. What's up?" I explained the situation. She listened without interrupting, then said, "You're telling me an HOA has master keys to homes and they're walking in whenever they want, correct? Multiple homeowners have documented instances. One woman was in the shower when they entered. That's breaking and entering, potentially burglary depending on intent. Even if they have a key, entering without permission is illegal. Why hasn't anyone reported this? Fear of retaliation. The HOA president has created a culture of intimidation through excessive fines and legal threats. Give me the address of the HOA office and the president's name. I'll pay them a visit." "Detective, I appreciate that, but I want to handle this strategically. If the police come in now, they'll lawyer up and potentially destroy evidence. I'm building a federal civil rights case. What I need is documentation that this is criminal behavior, which will strengthen my lawsuit. You want me to wait? I want you to be ready. When I file suit, I'll provide you with all the evidence I gather. Then you can pursue criminal charges. That way we hit them from both sides simultaneously," she considered. "How long? 2 weeks, maybe 3. Fine. But if anyone's in immediate danger, I'm going in. Understood?" My next call was to my colleague Janet Zimmerman, a civil rights attorney in San Francisco who'd made her name suing abusive homeowner associations. "Sam, good to hear from you. What's going on in the constitutional law world?" I filled her in. By the end, she was laughing, but it was the grim laughter of someone who'd seen too much human petness. "This is wild even by HOA standards. You want help? I want a co-counsel. This is going to be big and I could use someone with your specific experience. I'm in. Send me everything you've got. I'll start drafting the complaint." Over the next week, I became intimately familiar with every resident of Sunset Ridge who'd suffered under Patricia Wellington's regime. There were 47 homeowners willing to join the class action. Their stories painted a picture of systematic abuse. Martha Chen had been fined $8,000 for planting roses instead of the approved desert landscaping. When she couldn't pay, the HOA placed a lien on her house. David Kowalski had been cited for parking his work truck in his driveway. He was a plumber, and the truck had his company logo on it. The HOA declared it commercial advertising, banned in the community. He now paid $200 a month to park it in a facility 3 miles away. Rebecca Torres had been fined for displaying a small American flag on Memorial Day. The HOA said flags required architectural approval and could only be displayed on specific holidays, and Memorial Day wasn't on the approved list. The more I dug, the worse it got. Patricia Wellington had turned the HOA into a revenue-generating machine built on petty tyranny. The inspection program was just the latest escalation. Those master keys had been cut 4 months ago, and the guards had entered homes at least 80 times that I could document. I also discovered something interesting in the HOA's financial records, which were supposed to be available to homeowners, but which Patricia had made difficult to access. Marcus helped me pull them through official channels. The HOA security program was contracted to Sentinel Home Services, a company owned by Patricia's husband, Robert Wellington. The HOA was paying Sentinel $40,000 a month for 2 part-time guards. That was embezzlement territory. I called Detective Ramirez back. "I've got financial crimes to add to the trespassing. I'm listening." I explained the Sentinel contract. She whistled. "Self-dealing. That's illegal even in HOA world. How much has she funneled to her husband?" "Minimum $160,000 over 4 months, likely more if we go back further. And I'm betting the guards don't see most of that money." "When are you filing your suit?" "Monday. I'll email you the evidence packet on Sunday night." "Perfect. I'll be ready." That Friday, I got a certified letter from the HOA. It informed me that I was being fined $5,000 for disruption of official board proceedings and harassment of board members. It also stated that if I didn't allow the security inspection by the following Tuesday, I'd be fined an additional $500 per day until I complied. I scanned the letter and added it to my evidence file. Then, I sent a response letter on my law firm's letterhead. "Dear Miss Wellington, I am in receipt of your letter dated November 3rd. I reject all fines and penalties as illegitimate. Your inspection program violates the Fourth Amendment, and your retaliation against me for asserting my rights violates federal civil rights law. This letter serves as formal notice that any employee, agent, or representative of the HOA who enters my property without my explicit permission will be prosecuted for criminal trespassing. Additionally, be advised that I am filing a federal lawsuit on behalf of myself and a class of affected homeowners on Monday, November 6th. I suggest you retain counsel immediately. Sincerely, Samuel Irwin, Esq." That weekend, Janet flew in from San Francisco. We worked out of my dining room, finalizing the complaint. It ran to 63 pages and included 8 causes of action ranging from Fourth Amendment violations to RICO claims based on the financial fraud. We were asking for compensatory damages, punitive damages, injunctive relief, and attorney's fees. If we won on all counts, the HOA could be on the hook for millions. "This is going to make headlines," Janet said, reviewing the final draft. "Abusive HOAs are a hot topic right now. The constitutional angle makes it even better. I don't care about headlines. I care about stopping this woman from terrorizing my neighbors. You'll get both." Monday morning at 8 a.m., we filed the lawsuit in United States District Court for the District of Arizona. By 10 a.m., I was serving papers on Patricia Wellington at her home, a massive Mediterranean-style house at the entrance to Sunset Ridge. She opened the door in a silk robe, her face without its usual armor of makeup. "What is this?" she demanded, looking at the papers I just handed her. "Federal lawsuit. You've been served. Have a good day." "You can't sue the HOA, you're a member." "Actually, I can. See you in court." By noon, the local news had picked up the story. A reporter from the Arizona Republic called me for comment. I gave them the broad strokes, carefully staying within ethical bounds. "This case is about fundamental rights. No HOA can strip citizens of constitutional protections, regardless of what bylaws might say." The story ran online that afternoon with the headline, "Scottsdale HOA sued over home entry program. Constitutional lawyer says rights violated." It quoted Patricia dismissing the lawsuit as frivolous and claiming the HOA had every right to maintain community standards. That was her first mistake. When you're being sued for constitutional violations, you don't double down in the media. Tuesday morning, I got a call from Detective Ramirez. "We executed a search warrant on the HOA office this morning. Found boxes of documentation on the inspections, including notes from the guards about what they saw inside people's homes. Some of it's pretty invasive. They noted medications in bathrooms, financial documents on desks, that kind of thing." That supports our invasion of privacy claims. It also supports criminal charges. We arrested the 2 guards for multiple counts of trespassing. They're being arraigned this afternoon. Both are claiming they were just following orders from Patricia Wellington. Good. Are you charging her? We're building the case for embezzlement first. The trespassing charges are trickier because she didn't physically enter the homes, but conspiracy to commit trespassing is on the table. Things moved fast after that. The HOA's insurance company hired a big Phoenix firm to defend the case. Their first move was to file a motion to dismiss, arguing that I'd failed to exhaust internal HOA remedies before suing. Janet and I drafted a response brief explaining that when constitutional rights are violated, no one has to jump through administrative hoops first. The judge agreed and denied their motion. Discovery was brutal for the HOA. We subpoenaed every document, every email, every financial record. What emerged was a portrait of systematic corruption. Patricia had been inflating expenses, creating fake vendors, and routing money to family members for years. The inspection program was just one piece of a larger scheme to maintain control and generate revenue. We also deposed Patricia. It took place in a conference room at my firm, with her lawyers flanking her like bodyguards. She was defiant from the start. "Miss Wellington," I began, "when did you authorize the cutting of master keys for homeowners' residences?" "I don't recall the exact date." "Was it your idea or someone else's?" "It was recommended by our security consultant." "Who is that consultant?" "Sentinel Home Services." "Which is owned by your husband, correct?" her lawyer interrupted. "You don't have to answer that. It's public record," I said. "Robert Wellington is the sole owner of Sentinel Home Services, LLC. Miss Wellington, did you disclose your husband's ownership interest before the board voted to hire Sentinel?" "I don't recall." "You don't recall disclosing a massive conflict of interest?" "I don't recall the specific meeting where it was discussed." We went back and forth for 4 hours. She didn't recall much of anything when it came to incriminating details, but she remembered plenty when it came to justifying her actions. "The homeowners were lazy," she said. "They didn't maintain standards. Someone had to enforce excellence. And excellence requires entering their homes without permission," I asked. "It requires accountability. To you, to the community. Did it occur to you that what you were doing was illegal?" "We had legal advice that the bylaws permitted inspections." "From whom?" She hesitated. "Our HOA attorney." "Name?" "I'd have to check. We never found evidence of any attorney advising the inspection program. I'm convinced she made it up." 3 months into the litigation, the HOA's insurance company made a settlement offer. $250,000 split among all plaintiffs, no admission of wrongdoing, and a requirement that we drop all claims. It worked out to about $5,000 per plaintiff. I called a meeting of the class at the community center. All 47 homeowners showed up. I explained the offer and my recommendation to reject it. "This isn't about money," I said. "It's about stopping this behavior permanently. If we settle now, Patricia stays in power and she'll just find new ways to abuse you. We need a judgment from the court that what she did was unconstitutional and illegal." "But $5,000 would help," one homeowner said. "I've been struggling since she fined me." "I understand. But here's what I think we can get if we go to trial. Compensatory damages for each of you in the range of $20,000 to $50,000. Punitive damages that could total several million. Complete invalidation of the inspection program and potentially other abusive bylaws. Patricia's removal from the board, and full coverage of our attorney's fees, which means the HOA pays for everything." "What's the risk?" Martha Chen asked. "If we lose, you get nothing." "But based on the evidence, the law, and my 20 years of experience, I'd say we have a 90% chance of winning on most claims. The Constitution is on our side. They voted 43-4 in favor of rejecting the settlement and going to trial. The trial date was set for June, 7 months after I'd filed the case. In the meantime, Detective Ramirez's investigation bore fruit. Patricia Wellington and her husband were indicted on 12 counts of embezzlement, fraud, and conspiracy. The guards were offered plea deals in exchange for testimony. Both took them. The criminal case moved faster than the civil one. By March, Patricia had been convicted on 8 counts and sentenced to 4 years in federal prison. Her husband got 6 years. The HOA's assets were frozen pending restitution. With Patricia facing prison, the new interim HOA board approached us about settlement. These were different people, homeowners who'd been as victimized as the rest of us. They were horrified by what had happened under Patricia's leadership and wanted to make it right. Janet and I negotiated for 2 weeks. The final settlement included $1.2 million in damages for the plaintiffs, averaging about $25,000 each, complete elimination of the inspection program and surrender of all master keys, revision of the bylaws to remove abusive provisions, a neutral third-party manager for the HOA for 2 years, and payment of all attorneys' fees, which came to another $400,000. The judge approved the settlement in May. At the final hearing, she made a statement for the record. This case represents one of the most egregious abuses of homeowner association authority I have encountered in my career. HOAs serve important functions in maintaining communities, but they are not governments and cannot exercise governmental powers. The Fourth Amendment applies in HOA communities, just as it does everywhere else in America. I hope this case sends a clear message that constitutional rights cannot be contracted away. That evening, I stood in my backyard watching the sun set over the McDowell Mountains. My phone buzzed with congratulatory messages from colleagues, friends, and clients. The story had gone national. CNN wanted me for an interview. So did the Today Show. But what mattered most was the text from Harold. My wife and I slept soundly last night for the first time in a year. Thank you. That's what the law is supposed to do, protect people who can't protect themselves. Give voice to the powerless against the powerful. I'd spent my career on big constitutional cases, arguing about abstract principles before appellate courts. This case had been personal, immediate, and local. But in some ways, it was the most important thing I'd ever done. A few weeks later, I got a call from a homeowner in Florida. Their HOA was imposing fines for political signs. Then a woman in Texas whose HOA was trying to ban rental properties retroactively. Then a man in California whose HOA demanded access to his financial records to prove he could afford his home. The Sunset Ridge case had opened floodgates. HOA abuse was everywhere, and people were finally ready to fight back. Janet and I started a nonprofit organization called the Homeowner Rights Defense Fund. We took on cases across the country, always focusing on the most egregious violations of constitutional and property rights. The Sunset Ridge HOA, meanwhile, became a model for reasonable governance. The new board cut fees, eliminated petty rules, and focused on genuine community needs like road maintenance and common area upkeep. Property values actually increased once the oppressive atmosphere lifted. Turns out people will pay more to live somewhere they feel free. Patricia Wellington served 3 years of her sentence and was released on parole. I never saw her again, though I heard she moved to Nevada and stayed far away from HOAs. The 2 guards found different employment, hopefully jobs that didn't involve invading people's privacy. As for me, I continued my constitutional law practice, but with a renewed focus on property rights and HOA abuse. The Sunset Ridge case became a teaching tool in law schools, an example of how everyday tyranny can flourish when good people don't push back. I still live in the same house at 2847 Desert Vista Drive. The lock that Patricia's guards violated with their master key has been changed, though it doesn't really matter anymore. The new HOA board asked if I wanted to serve, but I declined. I'd rather be the lawyer residents call when things go wrong than part of the system itself. Every now and then, I'll see neighbors in passing and we'll nod, sharing the unspoken bond of people who stood up to power and won. Harold and his wife bring me cookies at Christmas. Jennifer and Craig had a baby and named him Samuel, which I found both flattering and slightly embarrassing. Martha Chen planted her roses and they bloom magnificently every spring, as they should. The case taught me something important about the law that I'd intellectually understood but never viscerally felt. Constitutional rights aren't abstract principles. They're the difference between sleeping soundly in your home and lying awake wondering if strangers will walk through your door. They're the boundary between freedom and tyranny, even in something as mundane as a homeowner association. People sometimes ask me if I regret buying in an HOA community. I tell them no. I regret that Patricia Wellington abused her power, but I don't regret being in a position to stop her. If I'd lived somewhere else, those 47 families would still be suffering. Someone had to stand up and say enough, and I had the knowledge and resources to do it effectively. The law is a tool. In the wrong hands, like Patricia's, it becomes a weapon of oppression. In the right hands, it's a shield for the vulnerable and a sword against injustice. I spent 20 years learning to wield that tool in service of the Constitution. The Sunset Ridge case reminded me why I became a lawyer in the first place. Justice isn't just about Supreme Court decisions and landmark precedents. Sometimes it's about telling two guys with clipboards they can't walk into your kitchen uninvited. Sometimes it's about standing up in a board meeting and saying no when everyone else has been beaten into silence. Sometimes it's about using your expertise not for corporate clients or big settlements, but for your neighbors who are scared in their own homes. That's what I did, and I'd do it again in a heartbeat. Because at the end of the day, the Constitution isn't a dusty document in Washington. It's a living promise that every American has rights that can't be taken away by anyone, including a middle-aged woman with a blonde bob and a petty dictator's mentality. The master keys were destroyed in a small ceremony at the community center, attended by most of the plaintiffs. The new board president, a retired teacher named Susan, used bolt cutters to cut through each key while residents applauded. It was theatrical and maybe a bit silly, but it felt right. A physical severing of the connection to that dark period. No one should ever have the power to enter your home without permission, Susan said as she cut the last key. That's not community. That's control. We're here to be neighbors, not jailers. I kept one piece of a cut key as a reminder. It sits on my desk in my home office, a small twisted piece of brass that represents everything wrong with unchecked authority and everything right about standing up to it. The months following the settlement brought unexpected developments. The FBI got involved, expanding the investigation into HOA corruption across Arizona. They found that Patricia's schemes weren't unique. Dozens of HOA boards across the state were engaged in similar self-dealing, kickbacks, and embezzlement. Our case became a template for federal prosecutors. I ended up testifying before a congressional subcommittee about HOA reform. Standing in that hearing room, explaining to elected officials how Americans were losing their constitutional rights in their own homes, felt surreal. But it mattered. Several states passed laws in response, limiting HOA powers, requiring financial transparency, and protecting homeowners' fundamental rights. The media attention brought challenges too. I got hate mail from HOA board members who saw me as attacking the very concept of community governance. Industry groups painted me as an anti-HOA zealot trying to destroy property values. I had to be careful to explain that I wasn't against HOAs themselves, just against tyranny in any form. HOAs can be wonderful when run properly, I told one interviewer. They maintain common areas, organize community events, and handle necessary administrative tasks. But they're not mini-governments. They can't override constitutional rights. That's the line Patricia Wellington crossed, and that's the line we have to defend. Back in Sunset Ridge, life slowly returned to normal. The new board implemented reforms. Term limits for officers, mandatory financial audits, transparent meeting procedures, and a homeowner bill of rights that explicitly prohibited unannounced inspections and protected free speech, religious expression, and political activity within reasonable bounds. They also revised the architectural standards. Homes could now be painted any of 30 approved colors instead of 5. Solar panels were encouraged. Small vegetable gardens were permitted. The ridiculous rules about car ages and flag displays were eliminated. The community became more diverse, more vibrant, less sterile. Property values did something interesting after the settlement. They dipped slightly at first as the criminal case made headlines, then rebounded higher than before. Apparently, buyers were willing to pay a premium for an HOA that respected their rights. Word spread that Sunset Ridge had reformed, and suddenly, we were a desirable community again. I attended a few board meetings as an observer, curious to see how the new system worked. The difference was night and day. Homeowners spoke without fear. The board listened and actually considered input. Decisions were made collaboratively, not autocratically. It was what HOA governance was supposed to look like. At one meeting, a homeowner proposed starting a community garden. Under Patricia, that would have been rejected instantly as non-conforming and visually inappropriate. The new board discussed it, asked for volunteers, identified a suitable common area, and approved it with guidelines that balanced aesthetics with functionality. The garden opened 3 months later, bringing neighbors together to plant tomatoes and peppers and herbs. I volunteered one Saturday, digging in the Arizona soil alongside Harold and Martha and a dozen others. We worked and talked and laughed, the way neighbors should. No one mentioned master keys or inspections or fines. That era was over, buried like seeds that would never sprout. "You know what I appreciate most," Harold said, leaning on his shovel. "I appreciate feeling like my home is mine again." That sounds simple, but when you lose that feeling, everything else falls apart. "That's what made the case so important," I replied. "Home isn't just property, it's sanctuary. Everyone deserves to feel safe in their sanctuary." Martha wiped dirt from her hands. "I've lived in 6 different places in my life. This is the first one where I fought to stay. Before, I would have just moved. But something about what happened here, about standing up together, it made this feel like home in a way nowhere else ever did." That's the paradox of what happened in Sunset Ridge. Patricia's tyranny was horrible, but the process of defeating it brought the community together in ways that normal HOA life never would have. We became more than neighbors sharing an address. We became allies who'd fought for something important and won. As the sun set that evening, casting long shadows across our community garden, I felt a deep sense of satisfaction. The law had worked the way it was supposed to. Justice had been served. Rights had been protected. And a community had healed. My phone buzzed with an email from Janet. She'd taken on another HOA case in Oregon, similar facts. Did I want to co-counsel again? I looked around at my neighbors, at the garden we'd built together, at the community rising from the ashes of Patricia Wellington's reign. I typed back, absolutely, let's shut them down too, because that's what I do now. I'm Samuel Irwin, constitutional lawyer and defender of homeowners' rights. I've argued before the Supreme Court about abstract principles of federalism and separation of powers. But my most important work happens in cases like Sunset Ridge, where real people face real tyranny in their everyday lives. The Constitution isn't just for landmark cases and history books. It's for Tuesday evenings when guards with master keys try to enter your home. It's for neighbors who plant the wrong flowers and face financial ruin. It's for teachers who park their dented cars in their own driveways and shouldn't be punished for it. Patricia Wellington learned that lesson the hard way, from a prison cell. The guards learned it when they were arrested. The HOA's insurance company learned it when they had to pay out $1.6 million. And most importantly, 47 families learned that their rights matter, that standing up to power is possible, and that the law can be a force for good when wielded properly. I still practice constitutional law at the highest levels. I still argue important cases about government power and individual liberty. But I also answer calls from homeowners in HOA disputes, and I don't turn them away. Because sometimes the most important constitutional battles aren't fought in marble courtrooms in Washington. Sometimes they're fought in suburban community centers in Scottsdale, Arizona, against a blonde woman with too much power and too little accountability. That's the work that matters. That's the work I'll keep doing. Because every American deserves to feel safe in their home, free from unreasonable searches and seizures, protected by a constitution that means something real and tangible and immediate. Patricia Wellington tried to take that away from my neighbors. She failed. And anyone else who tries will fail too, because there are lawyers like me and Janet and thousands of others who understand that defending liberty sometimes means fighting against homeowner association tyranny. The master keys are gone. The inspection program is dead. The community is free. And I'm standing watch, ready to defend it and others like it. That's justice. That's the Constitution in action. And that's why, despite everything that happened, I'm glad I bought that house at 2847 Desert Vista Drive in Sunset Ridge. It gave me the chance to make a real difference in real lives, to stand up for principles I believe in, and to remind everyone that in America, your home is your castle, and no HOA board can breach those walls without your consent. The sun has fully set now over the McDowell Mountains, and the desert air is cooling. I can hear my neighbors in their yards living their lives without fear. That's the sound of freedom. That's what we fought for, and that's what makes everything worthwhile.